like I come in, I see you, I go to probate court, file the necessary paperwork. How long does I get to the judge?
Well, you might not, if it's a properly drafted, self-proving will, that is, person had a will, it has the two witnesses and the notary, the client, let's say the surviving spouse, or whoever's named as personal representative or executor, all that means the same thing, they might never have to come to the courthouse. So as soon as a death certificate is available, and that is required, and the family signs the paperwork, that is, the person that's nominated as personal representative has to sign paperwork, each of the next of kin, whether they're named as a beneficiary or not, they have to sign some paperwork or have notice of the process. If everybody signed their paperwork, as soon as the death certificate comes, the lawyer can take it to the courthouse, meet with the staff clerks, they review the will, do an initial review, and typically in about half hour, you have your documents. The estate is open on that day without a hearing. The times that you need a hearing would be if there's a disagreement and you've got somebody not signing their paperwork. They say, well, I'm left out of that will. I'm not going to sign anything that says I know this process is happening. So if a family member doesn't want to sign their paperwork, or if you have a minor child involved, or if you have a disabled person who has dementia, they can't sign their paperwork and they're involved, or if maybe one of the next of kin is missing. Maybe they went to another state 20 years ago and nobody knows where they are, or even if they're alive, or how they're doing. Any of those cases would require a hearing. So typically you would file the case, the lawyer would file the case in with the judge, and then they would set a hearing date. I believe the docket's about 2 months plus out. Is that about right?
Yes.
At least 8-10 weeks out.
So if there could be a time when you have all your paperwork and you think you're ready to go, but you may have to have a hearing to open the estate.
So it could be as fast as 10 days or 2 weeks. That's pretty straightforward, or it could be several months if you have to have a hearing.